Good evening. I'm happy to be here once again, streaming live. I did not give everybody a chance to have notice ahead of the fact that I would be streaming tonight. This was a little more impromptu than normal. However, I'm hoping that many of you do have an opportunity and will see this lighting up on your emails and notices. So tonight I want to have a discussion on a few interesting matters that have come out. First of all, I want to wish everybody only good health. Remind you to continue social distancing, continue not gathering in groups of 10 or more. In fact, probably better with the shelters oneself's orders that are out for Miami, Dade, Broward, and Palm Beach, and most of the state, not to go out to any type of groups at this point. A couple things have gone on since we last spoke, and I last had an opportunity to speak with you here through the YouTube. An order came out where the governor clarified 718.1265 as well as 720.316. If you'll recall, and there's of course I don't want to leave our co-ops out, there's 719.128. So as we've discussed previously on a number of occasions, there are certain powers enumerated under Florida statute that give associations the opportunity to take probably greater power than is normally set forth under the statute in your documents in a case where the governor has declared a state of emergency. Now, the state of emergency, as we also discussed previously, was initially done as a result of hurricanes devastating the state, and the necessity for the boards, for the association. Good evening, sir. Necessity for the boards to go ahead and be able to govern their communities, make sure that people are coming in that should be coming in, prohibit people from coming in when it's unsafe, taking such actions to purchase either necessary repairs, generators, whatever it may be, to help sustain the community and preserve it as much as possible within reason and to the business judgment of the membership. And we're gonna visit business judgment in a future YouTube. That's a really hot topic right now that I've been dealing with. Anyways, some practitioners, especially those who just a little bit older than me, and I'm now old, but just a little bit older than me, have made it their point to come out on these boards that we discuss these issues and say, look, that was really meant for hurricanes, and we don't believe you can use it here with this pandemic. The younger ones of us, myself included, are willing to come, what I like to say, up to the line, not cross it, but push against it and say, listen, associations need to preserve the health, welfare, and safety of their members. They need to ensure, to whatever degree possible, that the property is well maintained and that people who are coming there can feel safe, especially during a period like this of a pandemic, that they're not subjecting themselves unnecessarily to people who have either exposed themselves or in fact tested positive or overtly have the virus and are showing clear symptoms of it. So with this kind of dichotomy between these two positions, last Friday, an order was issued by the Secretary of Florida Department of Business and Professional Regulation pursuant to the authority granted by Executive Order 20-52. And this is amazing because this is so on point to what we've all been discussing, and that's really the impetus for this action being taken. So under 718.1265, it said the emergency powers of a condominium, that again, because this is going to be also applicable for 720.316, emergency powers of a board of director during a declared state of emergency being conditioned upon a, quote, response to damage caused by event, close quote, is hereby suspended. And of course, the same thing is under 719, the Co-op Act. And what the effectively did is said, look, you don't need damage to declare not only a state of emergency, but to have the emergency powers under 723.16, under 718.1265 come to the association or be available to the association, if you will, to use those powers. Again, fight between more seasoned practitioners who believe that that provision was solely set up for hurricanes, and those of us who are somewhat seasoned, 20 plus years practicing, where we believe that this, in fact, should have already applied to this pandemic and to other such circumstances, as long as the governor invokes the state of emergency. But now the division has made it clear, pursuant to the authority with the governor, that a response because there is damage caused by the event need not be in the statute and not be applicable. So where otherwise you would have had a hurricane destroy building, property, trees everywhere, here, unfortunately, the destruction of this pandemic is lives, really, is families. But the destruction is not a palpable monetary loss, if you will, other than assessments, which we'll get to shortly. I'm going to address those tonight. Good evening, Marie. Thank you. It is really important that you look at this and now understand that because no longer damage of palpable damage, of physical damage to the property is necessary, these powers are now of the association, and the association, which I always refer to the board as the association, you are the corporate entity that governs. This now is important to be able to govern your community and make these tough decisions. And frankly, these are horrendously tough decisions. I'm dealing with a number of associations, both homeowner and condominium, who are seeking to limit guests, who are seeking to limit groups of people congregating together on the property. Unfortunately, a lot of people are looking at this as a vacation at one's home, and they're getting stir crazy, and they're feeling like it's important to socialize with your neighbor, have some drinks, barbecue, have the kids play, things that could not be further from the CDC guidelines that are out there. It's simply incomprehensible that people are doing this. And frankly, it's probably because of a lack of being educated as to what's going on and wanting to look at the news, which is depressing every night. I have here all the major networks watching every night, looking at what's going on, how they're reporting it. If you look now at CNN, Chris Como, one of their lead anchors, has tested positive and has some really distinct symptoms from the virus, and it's affecting him right now. He's quarantined in his basement, of course, using the opportunity, as I can understand it, to educate everybody on what's going on and how it affects him and reporting on it. But nevertheless, these are serious symptoms, serious cases that can occur within your community. So I have had associations, especially with closed condominium buildings, where you have very limited ingress and egress into the building, close off those entrances and literally tell members, their guests and invitees, that guests are not permitted, that if you are a tenant or an owner there and you're coming in from out of state, no matter by flight, driving, cruise ship, the Northeast or anywhere, that you must self-quarantine now for 14 days. They are desperately, and I think effectively, really effectively, using both the manager who's on site still and the board members who are very active to go ahead and limit that access, to limit the spread of the Covid19 throughout the building should it occur. They are also practicing not only the separation, they've closed down the pool, and we'll get to that also. Palm Beach and Miami have issued orders on the pools and other common areas. But they're also making sure that elevator buttons are being cleaned as much as possible. There are limitations. Associations, your boards, do not have to spend a tremendous amount of money and resources that it may not have to clean up after everybody else. You need to do what you're able to do. There's nothing that requires you to do more. If you can, it's wonderful. If you believe that you can assess the members to make up for a shortfall and take care of this, then you should be going at it and trying to do the best that you can. But it is not incumbent on you, and it's not your responsibility to do so for the membership. All right. So I think we've talked last time about guests, and I'll just reiterate that. There is no right of an owner during this period of time to have a guest have to live there with them at their property. Simply doesn't exist. Not at this period of time. I believe that an association can tell an owner no guests at this point. Okay? Especially transient guests, right? Guests who come, stay for the weekend, then leave, then come again during the middle of the week. You don't want that traffic, especially with the orders that are going on now, unless you are at a necessary job where it's called an essential job, where you're exempt from the shelter in place orders. You should be in your residence, and your members should be in their residence and not using that as an opportunity to socialize and potentially spread the virus. I have now written for a homeowners association that has a gated entrance, which always helps, of course, for the opportunity to make sure that all the members understand that we are limiting guests. We're not going to allow guests to come in on a consistent basis, as well as the fact that we do not want and will not allow people to congregate in the streets in front of their residences, putting others in peril. And that's really what you're doing. If you do that, you're putting people in peril. If you're not abiding by the CDC guidelines, 6 feet minimum. Now they're saying it should even be further apart. 6 feet social distancing and no more than groups of 10. So I'm doing it for homeowners. I'm doing it for condos. The reality is it may be difficult to enforce, and it's also going to be somewhat of a factor of the rest of the members not only complying with these orders, but also agreeing to some social stigma to the other members to let them know, listen, we're watching you as well. You're putting us in a position where we can get hurt, and you shouldn't be doing that. So unless there's any questions about guests, about limitations and so forth, I've addressed it in prior videos. I'll address it again in the future as it changes. I think this is a really important part of the statute that has changed now and has been clarified, actually. I mean, you're literally eliminating such an important part of it to justify the use of these emergency powers to now make it much broader and more far-reaching for the boards to enact provisions and take policies that will hopefully help preserve your communities from widespread virus outbreak. Okay, let's talk about the big issue, money, finances. A lot of associations are now coming to me saying, Guy, we're having issues. People are already asking us for forbearance, for payment arrangements. They're already coming into us and saying, look, we can't pay. Well, absolutely. I'm answering a question here, so pardon me. It's absolutely okay to email the community to inform and request them to avoid congregating within the community with neighbors and to limit, if not eliminate, having guests come over. It's important to state the governor has issued orders mandating shelter at home. Shelter at home doesn't mean you can't go out to CVS, to Publix, to Winn-Dixie, to Sam's Club, to Costco, to certain stores, Target, to get supplies. Shelter at home means you're not out there partying, you're not out there going to the community swimming pool, which I want to address in a moment as well. That is not what it means. It means that you're not congregating and you're not out there going to restaurants and movie theaters. Okay? So, back to the issue of collections. So what I've been asked for, Guy, what do we do about collections? We're already getting requests. Now, first of all, I want to be clear, and I'm not being heartless at all. This is a little early. This month's, March, April, the quarter, should not already be on the sites of owners to ask forbearance, right? Already you're looking at this should have been budgeted, planned for. These monies should already been earmarked to the communities. This money is the lifeblood of your communities. As board members, you know what it takes to run your community. You know the amount of money from managers to insurance to attorneys to upkeep, maintenance, repair, replacement, guardhouses, gate machines. All of that is so important for you to be aware of your budgets, that you know exactly how important it is to have your members pay and continue paying. And what happens when some of those members stop and others have to make up for the shortfall. So what do we do about all that? I suggest dealing with it like I would any request for an accommodation by any owner. If, Guy Shear comes to you and says, XYZ Homeowners Association, I really need a forbearance for the next 4 months due to the coronavirus. Okay, well, explain to me, Mr. Shear, why you need that. So what do I get to ask you? I basically get to ask you almost anything I want within privacy reasons, limitations, and of course medical. So if it's a medical issue, there's some issues with that as to how far you can go. But as far as a generalization on that, I can ask you, Mr. Shear, are you employed? Well, yes. Oh, okay. Did your employer reduce your salary? No, not at all. Okay. Then tell me what the basis is for a reduction in your assessment requirement. Well, I don't see one off the top. If I do say, yes, my employer has reduced my pay. Okay. By how much? And what other bills, what other expenses right now do you have? Certainly gas is not an expense. Certainly entertainment is not an expense. There's other things that could counterbalance your expenditure for the assessments from other things that you were doing, buying clothes, getting sports stuff, there's all kinds of things. And you are allowed to ask respectfully an owner to explain this, because the owner's asking you as the association to let them ride for X amount of months free of charge. So who pays for that potentially if that owner never comes back? Well, you do, and the rest of your members do. And that you do have a duty to your community to ensure that you do not put them as much as possible in financial ruin or financial hardship. Let's not be so dramatic. So you can ask the questions, how long do you need? The last thing I would do to all of this, and this I would frankly call your attorney, whether it's me or someone else, is put it in writing. This had to be a signed agreement. It should be a very, very limited agreement and a signed agreement. And you need to decide, are you paying interest? Are you paying late charges? You may agree to waive those based on paying 3 months from now, 4 months from now, with the caveat, and this is why it all should be really written by a lawyer, with the caveat that says, if you don't, all these charges will be accessible, including attorney's fees, costs, etc., just like any regular collections. I was asked by a really great board member today what happened with that Senate bill, which the House also passed, regarding the waiver of assessments for these 4 months and not being able to collect. Well, the good news, it wasn't included. So right now, there is no moratorium limitation on being able to collect assessments from owners. Okay? Most owners most collections now, or all collections for associations, will go forward. There is no moratorium on it. There's no, if you remember, I would have spoken to you about the fact that it could be a Fair Debt Collection Practices violation. That is not on the table. It is clear that the associations, for now, can go after any owner for not paying. Does that mean you shouldn't be compassionate? No. Does that mean you shouldn't be inquisitive and have a concrete plan with this owner or owners moving forward? Absolutely. All right. If you don't feel that the owner's given you sufficient information or been candid with you to the level that you believe they should have been, then you can say to them, listen, guy, I just don't see it. You haven't lost your job, or if you have been reduced, they reduced your pay by 10%. You're not driving all over the place. A lot of other expenses right now are not going forward. This community needs your money in order to pay our bills. Our bills come up every month. And if you don't pay, then we have to make up your shortfall. So we don't see it. Unless you can explain it better, I apologize. We're not going to be able to grant this. You need to approach this, by the way, remember selective enforcement, you need to approach this in a very clear way to all your members. You cannot say, well, guy I like, he's been here for 30 years. We don't want to foreclose on him. On the other hand, Joe here, he's Johnny come lately, and he's only been here a year or two. He needs to pay. It's got to be across the board. All right, last subject for today, and I appreciate everybody hanging with me. We're going on almost, I think, a half hour here. Last issue is pools and other common facilities. So, your association, especially condos, you could have a pool, that's a common area, pool, common element for condos, area for homeowners, a gym, whatever it is, a workout room, a meeting room, a lobby area with a TV that people congregate. The governor has passed now the authority for all the counties, and the counties have now adopted it, other than Broward technically, but I believe it'll be coming tomorrow or the next day, shutting down all these types of facilities. Now, again, lawyers are lawyers, and we sit there and we parse it, and I've seen some parsing of the Palm Beach ones that aren't clear as whether it applies to an association, although it does say private. To me, private is an association, right? Your pool at a condominium is not open for me as I drive by, and if there's open parking and I can get into it, to come and start swimming there. It's not a public pool, it's private. So as far as I'm concerned, this applies to everyone in Miami-Dade. It should apply to everybody in Broward and Palm Beach. That means any owners disputing the board's authority to close down pools, workout rooms, meeting rooms, lobby areas, anywhere where people congregate on either HOA, common areas, condo, limited common elements, are all to be closed at this point. No owners are to have access, their guests, tenants, and so forth. That is under the law. Again, Broward is shortly coming, but I believe it'll be there within a day or two, and it's justified under those general powers, those emergency powers that I just discussed with you. So both for 718, 720, and 719, under those subsections that we talked about earlier this evening, those subsections give you the authority to take this action, and you should immediately take this action. Last thing, and I promised that was last, but I do have one further comment. If you have security personnel, this should be a two-way street. Either talk with your security company's management or representative and see if they have masks or other protective gear that they will assign their members, their staff. On the other hand, let the people know let the security guards know as your protocols, as your posting orders, if you will, not to approach people in the car. They should be able to look at their ID from a distance, identify them, not take it, not go back and forth. You have a couple issues here, potentially. You get the security guard gets the virus from one of your guests, one of your owners who is in a loaner car or what have you, or the gate's not working, and they give it to you, and that gentleman or lady decides maybe the association's responsible and there's not an indemnification clause with the company. I'm reviewing one now, an agreement now for security, and frankly, this is a very large, very expensive community, and the agreement doesn't have an indemnification, doesn't have a hold harmless, doesn't have an insurance provision, nothing. Things we'll talk about at a future podcast, but YouTube podcast. But it's important to understand that there could be litigation getting that. Conversely, the person in the car receiving that card, their driver's license back from the security personnel, can also claim that they got it from him, and our association didn't care enough to ensure and screen the people working for it who are their agents, the agents of the association. So really important to keep more of a distance. You don't need to have these licenses handled back and forth. It's enough to look at it, and again, I recommend speaking with the security company and making sure that they provide some type of mask, some type of safety equipment to their personnel. Let's see, a couple questions here. The sign law gives homeowners the right to not pay for 4 months with or without an agreement. No, because so the sign law, the law was not enacted to do that. It is not it's not a right under the law not to pay for 4 months. It did not pass. What I'm saying is, if the board wants to consider an owner application for some type of forbearance, a month, 2, 3, 4, 5, 6, you're welcome to do so. You are welcome to ask almost any question you want without reason. And if you think you're treading on that gray line, call your counsel. Don't put this on your management company. That's not their bailiwick to make these legal determinations. Call your counsel, ask your attorney how to go about it and what to go about. What I'm suggesting is when all that's done and you've reached some type of understanding and agreement, the owner's okay with, the board's okay with, that has to be put in writing and signed by all parties. It has to have a due date and a consequence or a breach provision if they don't comply. What do you do as a management company if a board in a condominium refuses to shut the pool down? Well, I think what you have to do, and this goes in homeowners or any association you represent, if they are failing to comply with a county or state ordinance, I would recommend going through the council, making sure that you're looking at the right thing, and then provide that to the board and say, look, here's what it says. We have provided you advice, not legal advice, but we've provided you management advice that this has been passed and this is now a requirement, and we believe this should be required. We are prepared as your manager to go to the property, secure the facilities that should not be accessed by anyone until this ban is lifted. You chose not to allow us to do so, and therefore we are no longer responsible to the association should you be fined, sanctioned, or even there's some talk that some of these violations could be even a misdemeanor. And that you put in writing, you sign it, you send it to the board, you track that it went to the board, or you ask the board to sign that they understand and appreciate that, and you move on. That's it. Everybody here is an adult. Everybody here makes decisions that they think are the best interest of the parties that they represent and the things that they are doing. And you can only give information that is accurate and complete. And then the other party needs to make a decision based on that. And maybe they'll consult counsel for the association and come up to a final decision. But that's what you need to do. Put everything in writing, everybody. This goes for everything. The more you put in writing, the better it is. The less you put in writing, the more of an issue you're going to have in the future for a he said, she said. And we'll talk about that as a future podcast. Another question, even though they will pay after the fact. Yeah, sure. So I say to you, board member, it's Guy Shear again. I'm see you in 4 months. 4 months come about. A guy, where's that payment? You owe us, $100. Wow, I'm so sorry. Was it 4 months? I thought we said 5. No, it's for sure 4 months. And you agreed no interest, no late charges as long as I paid. Yeah, but not at 5 months to a judge. And you say, Your Honor, Guy Shear agreed to pay in 4 months, and we agreed to forbear any collection of late charges or interest. And he didn't comply. So now we have a right to do so. Judge says, well, where does it say that? Here's our document, Your Honor, right there. Oh, I see that. Guy, didn't you sign this? I did. I wasn't sure about 4 or 5 months. Or, Your Honor, I lost my job permanently. It was agreed on. Very, very important to do that. I'm getting a little fit to deal with me, but we've put in some lighting now. We're really trying to spruce up our presentation. Really appreciate everybody spending the time asking questions and following me. Please subscribe. Please click on the bell when it does come out. Again, thank you so much. Be safe. God bless you. God bless this great country of ours. I'm sure we'll come out of this, and I look forward to that sooner rather than later. All the best to everyone. Thank you and good night.